Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Our aim for this podcast episode today is to take you, the listener, through the step-by-step process of how to report, be safe, and work with police while reporting domestic violence. If this is triggering for you, we recommend that you please call 1-800-RESPECT, or if you need to speak to someone, you can call Lifeline on 13 11 14. And of course, if you're in immediate danger, always call 000. But today we're so excited to have the amazing Inspector Dwyer here with us, and I'm very nervous if you can't tell, and of course, the lovely mum, to talk us through this process. So thank you so much for your time, Inspector Dwyer.
Thank you so much, ladies. It's a pleasure to be here.
Now, before we start, I'd like to acknowledge the Ghanaian people, the Aboriginal and Torres Strait Islander owners of the land where we're recording today, and pay our respects to the elders past and present and emerging. I recognise their connection to the country and the role in caring and maintaining country over the thousands of years. May their strength and wisdom be with us today. Now, Inspector, is there any chance you could just give us a little run through of what your role is in the police service?
Yeah, sure. Thanks, Laura. And no need to be nervous, ladies. At all. I feel I'm absolutely privileged to be here and to engage with both yourself and your mum and your listeners. So my name is Melissa Dwyer. I'm an inspector in the Queensland Police Service. Yesterday I notched up 32 years of police service, having been sworn in 1991.
Yeah. Congratulations.
Thank you. I was the first of the post-Fitzgerald police. So my role here, what I have done over the past 32 years, which has ultimately led to me to my current position, I've been a long-term detective in the Queensland Police Service, investigated domestic and family violence homicides, was an officer in charge of prosecutions where I led all things domestic and family violence in the court space. I've also then worked in strategic policy space, writing policy across government, primarily in domestic and family violence, following the Not Now, Not Ever report released by Dame Quentin Bryce. And most recently, I've been promoted to the role of Inspector Manager of the State Domestic Family Violence and Vulnerable Persons Unit. So a whole lot of things I've done in my career, and I've been incredibly fortunate to deal with victim survivors at many stages of their journey through the criminal justice system and their engagement with police. My role here at the Domestic Family Violence and Vulnerable Persons Unit is to strategically align and enable the QPS to respond to domestic and family violence. So what that broadly means is looking at policies and practices and evidence that sits both at a state, national or international level, and how we can use that to ensure that our practices are such that we are delivering the best possible domestic and family violence service to the people of Queensland. So strategically aligning the service to respond to domestic and family violence. And we acknowledge the Commission of Inquiry into Queensland Police Service responses to domestic and family violence, and prior to that, the Women's Safety and Justice Task Force reports that laid bare the incredible police practices in our response to DV, and also our less than optimal police responses that led many people making comments to the Commission of Inquiry and the Women's Safety and Justice Task Force outlining their disappointment at the police service and our response.
I can't thank you enough for the service that you've already given everybody, but also the effort that you're making moving forwards to make change, and the support that you've already provided to so many people.
It's wonderful to hear. It really is.
So we're really a practical podcast that our listeners, they just listen to us to get maybe just an insight into what they're going into. What is it that they're going to expect? And you couldn't be like, I think you are probably one of the best people we could ask these questions, knowing though that a lot of our listeners aren't just in Queensland. Like the process, of course, will be different in each state, but basically would be similar-ish, wouldn't it, in each state to reporting DV?
Yeah, it will be somewhat similar. There are some states that have a mandatory reporting requirement to police. That doesn't exist here in Queensland, but effectively the provision or telling one's story to a member of a police service or police force is relatively the same. We're asking people to lay bare matters that have significantly impacted them and their children, to provide that information to us to try and provide that immediate support.
So let's start with, first of all, I guess anybody who's listening, number one priority before you do anything is to keep safe before you've even walked into a police station or reported it. Do you have any tips or anything that you could tell our listeners on how they can keep safe?
Yeah, sure. And it's going to be really dependent upon everybody's own personal circumstances. What we're learning now is the role that technology plays in victims' survivors' safety. And we understand that there are certain devices that we rely upon day in, day out as a means to keep us connected with loved ones and our support systems. Invariably, though, those tech devices also provide a perpetrator with an ability to track us. Things such as AirTags, which are designed to be attached to certain matters of importance. I have one on my USB, which is my lifeline to my work. Invariably, that can be used to track where I am. Matters such as family sharing on mobile phones, making sure that that is turned off before you come into a police station. So understanding what is it that you have in your possession as a victim survivor, and is there an ability to turn off these types of known devices that would stop a perpetrator from understanding and being able to identify where you are if you want to report or when you report domestic and family violence to police. So that's a really important start for our victim survivors.
So then you said the next step was your timing of going into a police station. So did you want to talk us through what you mean by that?
So the timing for a victim survivor to attend a police station is a matter that will depend upon the circumstances for each person. They understand what is best for them and their circumstance. So if they have a perpetrator that is attending work or attending an event, that may present as an opportunity that might provide an opportunity to engage with police. We understand, though, that there are some perpetrators who are that controlling, that there are limitations on where victims can attend and at what times. And in those circumstances, we know that we have provided opportunities for victims to engage with police and at other locations that might present as shopping centres where they are, in brackets, permitted, which I struggle to accept, but they are permitted to attend, and that then provides them with an avenue in which to seek support and guidance from police and report domestic and family violence. So it is dependent upon their own circumstances. They understand their risk better than any other person. They understand what the perpetrator's movements are and when best presents as an opportunity for them to engage police.
If, say, for example, anyone who was listening today was in that situation where their ex goes with, or their partner goes with them to the hairdressers, their partner goes with them to the school drop-off, and like you said, the opportunity might be when they're doing the grocery shopping. How do they coordinate that with a police officer?
Yeah, that's really difficult. With the exception of a cold attendance at a police station, there might be another opportunity for them to engage online with police at a time when it is safe for them. So in Queensland, we have an online reporting capability for victims to make contact with police. We have a capability also that they can request, the victim survivor can request a call back from police at a certain time or by a certain member when it is best and safe for that contact to occur. So having a capability to meet the needs of the victim survivor is really, really important. They understand their risk and they understand when it is best for them to report domestic and family violence to police.
So say maybe our listeners aren't in that situation. A lot of them have left their ex. Mm-hmm. They're experiencing, elevated, escalated behaviour because they have left. What can someone expect when they walk into a police station? Like a lot of our listeners and a lot of people I know who've been through this, they've never been to a police station. They've never been in trouble. They've never interacted with a police officer usually. And just the whole place seems like a foreign world where naughty people go, basically. So what can they expect when they walk in those sliding doors or open the door?
A really great question, Laura. It is acknowledged that police stations are a really cold and sterile environment. And I mean cold in the emotional sense. are really sterile. They're less than inviting, and they are specifically designed in a way to keep members, police service members, safe. So there is generally a barrier as well, such as a front counter, and in more recent times with COVID, the Perspex glass to keep our members safe. So it's understanding that they're going to walk into that front door of the police station. They're likely to be at a heightened sense of emotion with expectations, rightfully so, that when they talk to police, that they'll be heard, they'll be listened, and they will be believed. What we know is that we do have those sterile locations, and arising from the Commission of Inquiry into Queensland Police Service responses to domestic and family violence, there was a recommendation that we have a room that provides an ability for a victim survivor to provide their information, their most intimate information, to police in an environment where they can't be overheard by other members of the public, so that they can request that they attend a dedicated, safe, secure room and private room to provide that information to police. So upon entering those front doors of that police station, the victim survivor could attend and indicate that they would like to report domestic and family violence, and they'd like to speak to a police officer in a private location. At that point, the victim survivor will be taken into the room, the safety room, and it's much better than perhaps what you would envisage. There are some soft furnishings and that environment that's been created to put that victim survivor at ease so that they can provide their information to police. And, I run have run police training here with the Queensland Police Service, and as part of one of the exercises, I say to the members, okay, I want you to turn to the person that you don't know beside you, and I want you to outline the most intimate details of your life to that person. And they look at me like, you want me to do what? And I say, right, before anyone actually does that, put yourself now into the shoes of a victim survivor, and that's exactly what you are asking them to tell you as someone who's unknown to them. So trying to flip that lens so that they can understand how difficult it is for a victim survivor to provide the most gut-wrenching, intimate details of abuse and domestic violence that has occurred to them from somebody that supposedly loved them and may still well love them. So trying to flip the lens and understand how difficult this is, and understanding the environment in which we're bringing survivors into a police station and making it in a way that is comfortable as much as we possibly can to get them to be able to feel comfortable to provide their story to us.
The other aspect of that, Inspector, is that if they're standing at a counter, they are I would suggest some people would be at a really grave risk if somehow they've been tracked to the police station and they're visible, so there's that element as well of privacy and security in another room.
Yes. So if any of our listeners are listening today and they haven't gone in because they are worried, knowing that you can request to go into a private room that won't look as scary and sterile.
In Queensland, at least. Yes.
Okay. So then, what happens next? So they go in and hopefully they're invited into that nicer room to talk. Like, what should they expect? What happens? Like, do they just let it all out and just tell it as it is? Or are they asked specific questions?
Are they videoed?
Do they have to type things? Like, what happens next in the process?
Yeah, sure. So the police officer will ask the victim survivor to outline all of the instances of domestic violence throughout the history of their relationship.
Well,
whoa,
that's a lot.
Whoa.
And generally that is the officer in Queensland will record that by their body-worn camera that's fitted to their police uniform.
Okay.
So it is, yes, it is visible, but it's not meant to be a barrier to that victim providing their version to police. So the police officer will guide and prompt the victim survivor to provide their information, outlining those instances of domestic and family violence to them in that conversation. And the reason why the Queensland Police Service have moved to wanting to know all of the history is that historically, we have responded to the incident at the time. And that historical response to an incident doesn't take into account what has happened in that person's relationship from day one of meeting or the first instance of domestic and family violence to the last instance. So it is but that previous response was but responding to part of what has been going on for that person. And it's that context that sits around all of those other matters that provides that real deep understanding of the pattern nature of DV and being able to identify who is the person who is most in need of protection. So, for example, if police respond to just one incident where the victim may have, in self-defence, defended themselves by striking out at the perpetrator, if we took that incident focus, we may get a misunderstanding that that may be a response to years and years and years of abuse, and this was but a self-defense mechanism. So understanding the context of the relationship, understanding and identifying that pattern nature of DV is really, really important. And it provides us with real deep understanding of what does risk look like for this victim.
If any of our listeners are worried because they don't know the exact dates, they shouldn't be worried. They should still tell their story, shouldn't they? And because I find when I'm taking statements for an affidavit, a few prompting questions like, well, was it football season, or where did it happen? Was it around someone's wedding or engagement? It doesn't matter, does it, if they get the dates roughly right, but not exactly right at this stage of the game?
Yeah, that's exactly the case. Absolutely, Lynn. It is about, I mean, they will remember what happened to them. They may not remember the month, but they may remember it was just before Grandma's 83rd birthday party, a couple of months before then. So the dates don't necessarily matter, but the incidents the matter, as in, where were they standing? What happened? What was the respondent saying? That's the real deep, rich information for us.
So the other flip side of that is because, like you just said, if you asked your members to turn to their person they don't know and tell them all the intimate details, is there scope? Because I know a lot of people don't want to cry in front of people they don't know. They don't want, but if you went to a psychologist and detailed, if you've been a victim survivor and detailed your backstory, of course you're going to cry. Is there allowance for that? Do they is it okay if one of these victim survivors walks in and tells their story and is really emotional?
Absolutely. And in fact, if we were not empathetic and understanding that, that people are going to cry, then we're in the wrong business. Absolutely. This is the most intimate, most heartfelt, most impactful things that have happened to them. Now, not everyone will cry. Everyone deals with trauma differently. But, I think that is an anticipated and, dare I say, expected emotional outcome. So, that just because they're crying matters nothing to our investigation. It demonstrates, if anything, it demonstrates the sheer impact on that victim survivor.
And then that's great. So if anyone's worried about going in and losing their biscuits for a minute because you're telling a big, horrible story, then you'll feel okay because they're used to and they expect that to a degree. So it's okay. The next step is, so they've told their story, they've told them the incidences and roughly when they think that all of these things have happened. What happens next?
So during that assessment, police will consider whether there is sufficient evidence by which to make an application to protect the victim survivor. So in Queensland, if a victim comes to a police station or reports domestic and family violence, they don't even have to come to the police station. But if they report domestic and family violence, police are obligated by law to investigate that domestic and family violence incident. So coming to a police station for advice, unfortunately, does not remove the mandated legislative obligation on police to investigate that matter. So a victim survivor coming to a police station, a police officer will commence an investigation with the view of understanding whether immediate protection is required to be provided to that person. That immediate protection can be in the form of the issuing of an order, and it will depend upon your state or territory or even another country as to what that order looks like. But effectively, it's an order prohibiting the other party from doing certain things that are akin to domestic and family violence. So in other states, it's recognised as family violence. That's why I say akin to. So it is, police are looking at, is there sufficient evidence that I can put before a court where a court can issue a final protection order?
Right. Do the police look at that and determine that while the person's still there, or does the victim survivor go home?
So it could be either of those options. So the police officer is, after hearing the information from the victim survivor and that being recorded on the body-worn camera, they may at that time or at a later time convert that into a affidavit and have the victim survivor sign up an affidavit outlining the domestic and family violence allegations, and the officer may, with that matter, and seeking evidence from perhaps other witnesses, looking at computer systems to understand previous orders of that person with perhaps other parties or their compliance with those orders, looking at their criminal history and their domestic violence history, and they are two different matters. They will assess whether there is sufficient evidence, which in Queensland is on the balance of probabilities, for an order to be issued. Now, they may arrive at that decision whilst the victim survivor is still with them at the police station, or they may arrive at that decision after the victim survivor has left. And that may be dependent upon the availability of the evidence. And, it might be that the officer may need to obtain some Facebook messages or get a affidavit from a witness, maybe perhaps a neighbour or a friend who may have been present when a domestic and family violence incident occurred, or may require an affidavit from a doctor if injuries have been reported. So there are so many different circumstances that may impact when a decision is made by a police officer, but invariably it is a requirement that we obtain all evidence to support the making of a protection order by a magistrate's court in Queensland.
I think I need to ask a couple of what ifs, and these are, as you know, we've received stories from listeners of things that have occurred. And so what happens if they go in, they tell their story, they provide what's happened, and then they don't hear back from the police at all? What should they do in that instance?
So the officer should provide their details to the victim survivor, and the victim survivor can contact either the police officer direct or can contact the station and seek advice. Now, the reality is the police officer should be proactively making contact with the victim survivor and keeping them up to date. So there should not be an expectation on a victim survivor to what I would call chase a police officer up for information. So the officer should be saying, this is where we're at, this is what next looks like, I've taken out an application and the matter, is going to courts, say like next Wednesday or whatever it might be.
And what about if they've gone in to share their story and to get help and they're turned away? What can they do in that instance?
Yeah, so in Queensland at least, the Queensland Police Service have imposed some policies and standards before officers can even arrive at that decision. So they must engage with their supervisor. They must outline the nature and circumstances of the investigation and the reasons why they don't believe that there is sufficient evidence to support an application for a protection order. And they must seek approval from, and the approval to be given before that victim survivor can be turned away from a police station. So it might be that there just isn't sufficient evidence at that time to support an application. Now, we are talking about a lesser standard of proof than a criminal trial, so we're talking balance of probabilities, whereas in a criminal setting, it is beyond reasonable doubt. And they are very different legal terms, but the standard of proof for a civil application, which is a protection order, is much less than beyond reasonable doubt.
Inspector, sometimes, we're talking about coercive control a lot these days, and it seems to be that coercive control that is most likely, I think, to lead to real violence or even murder of the victim. But reporting coercive control is tricky because each incident of itself might not reach a standard that would permit a magistrate to make an order. But put together, as you said, there are a pattern of behaviours. So all of those things together may well be sufficient to get an order for domestic violence. It would be, I guess, an interesting point if a person could go into a police station and have it just placed on record, the various incidences as and when they occur. I know that sounds a little bit pie in the sky and it could stretch your resources, but it's tricky, isn't it? That sometimes that thing so what, he took your phone, and you're complaining, or
so what you're asking is how do people report coercive control patterns to a police officer?
Well, you do take all the fun out of it.
Is that what you're asking, Mum?
Yes,
So, Inspector, have you got any tips for any listeners or victim survivors who've come out of a coercive control relationship or are still in it? How do they report those incidences that do not seem so bad individually?
Yeah, so it's a really interesting space with coercive control for the Queensland government. So at this point in time, coercive control is not a criminal offence. There is a bill currently before Parliament that seeks to introduce coercive control as a standalone criminal offence. What I understand is that that bill is set to be passed. But the expectation is that it will not come into effect until January 2025. Now, from the date of passage, which it hasn't passed yet, to when it's implemented, there will be significant investment in community understanding and awareness of coercive control and what that means, so that victim survivors and perpetrators know what coercive control is before a new law is implemented. However, in the domestic and family violence space, coerce is actually already covered within the DV legislation for Queensland. So the coercion, though, is not as defined as clearly as what the criminal offence is. So the criminal offence bill, at least at this point in time, is more than one occurrence of domestic and family violence. That is either coercive or controlling with the intent to cause harm to a victim survivor. Now, causing harm is not required, just an intent to cause harm. That's what the criminal offence at this point, subject to passage, is looking like. And that can still change. Whereas in the domestic and family violence space, the coerce is not as defined as what the criminal space is. So it may be that those instances of coercion can extend to one incident. It may be that it can extend to a varied nature. But those instances, Lynn, that you spoke of about, that look or those subtle behaviours that could be explained as perhaps usual behaviours in that relationship, that's going to be the real, I won't say difficulty and I won't say concern, but it is, it's a challenge for the police to be able, and victim survivors, to say that these subtle behaviours are actually coercive controlling behaviours when that criminal offence comes into play.
Yeah. And look, I think as long as, everyone tries their best to put their best foot forward going through this time of sorting all this out in the future, in 10 years, hopefully.
I think so.
There'll be a good...
And I think naming it and having the public aware, it's not just the victim or the perpetrator either, I think, Inspector. It's the family, the public. So if one of your relatives is in a relationship where you're identifying from the outside a particularly controlling behaviour, you can educate them by, maybe sharing some information, because it wasn't that long ago, and I've been doing family law for about 33 years, that it used to be if there were no bruises, it didn't happen. And so, and even before the before the Domestic Violence Act came out in Queensland, it was routine for police to say, "Oh, it's a domestic matter, we don't get involved." So I'm hopeful, because we've come a very long way, and I can hear that you have the will, and the people have, at the police have the right understanding. I loved it when you said that women know, or mostly women, that they know the risk they're under. They know. And I've had that many times. I can't leave. He'll kill me.
Absolutely. They understand their circumstances better than you and I. I mean, they've lived it. They've breathed it. They get it.
They know the rules.
They know the rules, right? Those rules that are imposed upon them by the perpetrator.
Yes.
Those other behaviours. So I agree, Lynn, we've come such a long way in such a short period of time, but I won't rest until there is no domestic and family violence in Queensland. That's what gets me out of bed every single day. I don't understand how the people who love us the most are perpetrating these types of behaviours. So that's what drives me fundamentally day in, day out. But it's those other behaviours that we really now recognise as domestic and family violence. And the research, a lot of the research and the lived experience by victim survivors indicates that, the bruises will fade and the injuries will heal, but it's that trauma that never goes away. And so recognising now that these other non-physical forms of violence are just as, if not more, impactful, and that real recognition that the emotional abuse, the psychological abuse, the economic abuse, these have just as long-standing impacts, if not longer, than those forms of physical violence.
And it can continue post-separation, the coercive control.
So I'm just going to circle back, and I want to get us to just at least to the court door. If they have, not provided enough, or if the police determine that it is not something they're going to move forward with, can a victim survivor go back and report another incident or continue to report? Is that allowed? Is that okay? Or once they've gotten a no from the police, we're not going to do anything, should they not go back?
I would encourage, if there is domestic and family violence occurring in someone's relationship, they should be reporting it to the police on every single occurrence when it is safe for them to do so. The indication that there is insufficient at this time does not and should never preclude somebody from being able to reach out and say, I wanted to let you know this has happened to me, and for that police officer then to look at that matter afresh in the context of this new information. So a hard no is only a no at that point in time. And if there is further evidence that comes to light, or there is a further incident, then that may be the difference between taking action and not taking action. That being said, though, if a police officer determines that there is insufficient evidence at that time to take action, that does not stop and has never precluded a victim from attending a courthouse and making an application for a protection order. In the first instance, we would prefer that a victim attend a police station and provide that. But let's just say, for example, that there is insufficient evidence, then that victim survivor can still take action by attending a courthouse and making an application for a protection order.
That's good to know. So anybody out there who, they didn't have enough evidence, they've walked off from the police, nothing's happened, you can keep going back, and alternatively go and take it into your own hands and go to the court and file your own private. Now, one of the things I think that holds a lot of people back from making any report at all is the fear of their ex being told. So can you explain to us and to the listeners, if a victim survivor has reported DV and the police are acting upon it, when is the first time that their ex is alerted to this, so that, if someone's listening today, they can be aware of that and make safe plans?
So we probably circle back a little bit to your first questions, which is when does the police officer make a decision and is a victim survivor informed? So in the context of informing a respondent, the legislation requires the police to give an opportunity to the respondent to address the allegations that have been made. So the police must offer an opportunity for that respondent to provide their version of the incident if they are not, at the police station at the time, which would be, on the majority of occasions, the victim survivor will attend by themselves or in company of a support person to support them in their reporting. So the police officer must offer an opportunity to the person to provide a version of their events, and that is natural justice and procedural fairness. So that perpetrator has rights in the same way as if, let's just say, for example, the true perpetrator made a report to police, we would give the other party the right of reply by providing their version. So that will be the first instance that they're informed. If the police officer takes out or issues an immediate protection in Queensland, it's in the form of a police protection notice. That must be personally served by the police officer they're called the respondent party or the perpetrator. So we must personally serve that on them and explain to them what this document means. So it is an immediate protection to the victim survivor before the matter is heard at court. And it may preclude the respondent or the perpetrator from doing certain things, such as not contacting the victim or not living at the address where the victim lives, regardless of whose name the premises are in. So the natural justice and procedural fairness must apply. We offer the opportunity for the respondent or the perpetrator to provide their version, and we personally serve the documents upon the party and inform them what the prohibitive conditions are and when the court date is. Now, in the event that a victim survivor attends a courthouse and makes an application for a protection order, the Queensland Police Service serve all domestic and family documents, regardless of who is the applicant, and we serve them on the parties. So in the event a victim goes to the courthouse, a court may issue a temporary protection order, or they might just have the application for the protection order without a temporary. The police service will serve those documents on the perpetrator.
And that can cause more escalation in some instances. Do the police, do you have any recommendations for anyone who is a victim survivor who may be about to be going down this route of, because again, it is fear that holds them back. How are they able to be safe in that moment if they're very, very worried that now that they've been told them, how do they keep safe?
Yeah, sure. And that's a really, really important question. And the courthouse acknowledged that there may be instances where documentation can't be served until the victim survivor has put in place certain parts to keep themselves and their children safe. So it's really, really important for a victim survivor to engage with a DV service provider and to enact a safety plan. And that safety plan comes, it effectively starts from the moment they seek that safety plan. But there are certain aspects that may escalate risk, such as taking action. We need to be cognizant that, what does this mean in the context of risk, and to mitigate that risk by putting in place other safety planning, other safety aspects to keep themselves and their children safe. So we acknowledge and understand that this can escalate, but there are options to keep themselves safe by engaging with the DV service provider and creating a safety plan. There are also mechanisms in place to keep people safe whilst they attend court, whilst they're at court, whilst they're giving evidence at court. So whilst they're in the court environment, either the bailiff or the courthouse or the police officer will be able to keep them safe and put in place mechanisms to affect that. But a safety plan, I cannot speak more highly of the need to have a safety plan. It's just such a necessary thing for victim survivors.
What you're saying is it's important for victim survivors or our listeners, if they're going to report this, to also ring, in Brisbane, it's Brisbane Domestic Violence Service or a service in your state or in your country even that can work. Do they work hand in hand with the police? Like, is there a liaison? Is there some sort of back and forth sharing of information between the police and the domestic violence services, or does the victim survivor interact between?
Yeah, so if in the event of safety planning, it is a plan between the DV specialist provider and the victim survivor. They have such deep understanding as to what safety looks like, and they work through not only the safety planning for the victim survivor, but safety planning for the children. Do the children know what to do in certain circumstances? Is the phone always charged? Is there always petrol in the car? What's their safety plan? Who are they going to? That's real specialisation required in creating strong safety plans. So it's generally not a matter that the police delve into. In terms of safety planning, though, information sharing, my apologies. There is information sharing laws that enable the DV service providers and other government agencies to share information, including the Queensland Police Service. But there are really strict and tight controls on what information is shared and for what purpose by whom and for, what is its intended use. And that's to acknowledge the sanctity and the confidentiality of information received by and used by police and other agencies. So there must be an immediate threat to the health, safety and well-being of a person for information to be shared or to assess whether that serious threat exists.
We're going to have to wrap it up today, but I would love to do another episode with you on the court process and what to expect there. If anyone is worried that they've got their protection order in place from the Queensland courts or police, and they go on a holiday to New South Wales and that their ex turns up there, does the rules still stay in place in New South Wales?
The orders.
The orders?
Yeah, absolutely. So a number of years ago, the Queensland government and other states and territories passed legislation that recognises the ability for an order to be recognised across the whole country. So let's say, for an example, an order made in Queensland today, that is nationally recognised across all states and territories. And in the event that there is a breach of that protection order in New South Wales, let's say, an example, Byron Bay or Yamba or Sydney, police down there can take action against that offender in the same way they could as if it was an order issued in New South Wales.
Well, that's good. That's comforting for people. And then lastly, Melissa, before, I'd love you to tell us some of the developments that are happening in the Queensland Police, but also the last question I want to ask is for any of our listeners who feel like this is an ideal walkthrough of what to expect and what happens, but what should they be doing if they are not getting this kind of process that we've detailed today, and that's not what they've got, and and they're facing the opposite of that, or no one's listening to them, they're not being heard, and is there something they can do to get heard if they're not?
Yeah, absolutely. So in Queensland and from speaking with my counterparts in other states and territories, there are domestic and family violence specialists in police stations or in districts that can provide that support to victim survivors. So in the event a victim survivor it doesn't get the level of service that they believe is required in the outcome, they can engage with the domestic and family violence coordinator or the equivalent in other states, or the specialist domestic and family violence police officer, to give them this, to support them and provide them the assistance they so deserve and be able to navigate this system.
All right. Well, that's a good thing for any of our listeners to remember to ask to speak to that person. And then lastly, I think to end on a higher note and a hopeful note, looking towards the future and continued improvement of this situation for everybody, what kind of things and changes and upcoming developments are happening at the moment in the Queensland Police?
Yeah, sure. So the Queensland Police Service has really heavily invested in upskilling our members. So before the Commission of Inquiry recommendations came out, the Queensland Police Service embarked upon a lot of training. And so we developed a coercive control learning or training product for our members. And that product was to try and provide an understanding of what coercive control looks like and what it is before officers then have to turn their minds to what is this new legislation? What is the evidence that I need? So it was like an introduction to coercive control. So we've done that, and that product was reviewed by Australia's National Research Organisation for Women's Safety, ANROS, and they supported that product. Every single police officer, including the Commissioner of Police, was required to undertake that coercive control online learning product. Yeah, so that's the first time we've made sure that every single person knows what coercive control is and they understand how it fits within the domestic and family violence environment. We've done a whole lot of training of our members. So we've introduced 5 days of face-to-face training for every QPS member up to the rank of superintendent. Now, superintendents are generally in charge of our districts and all civilian members who have contact with the public. So it's a 5 days face-to-face domestic and family violence training. That's a really huge investment that we've made. In that 3-day training, so there was 3 days and then a further 2 days, that's the 5. In the development of 3 days training, Judge Deborah Richards, who headed up the Commission of Inquiry, she actually sat in that training, and she heard firsthand what officers were being taught in relation to domestic and family violence. We've developed a 5-day DV specialist course. So that is our members who operate as DV specialists in their area. They have to do that training on top of the other 5-day training, and it's more nuanced to the specialist requirements of their role. We have a leadership course, but fundamentally what sits behind all this is a victim-centric, trauma-informed practice. So generally that was applied in a sexual violence setting, and I thought, why do we just have it sitting there? Why aren't all police applying this to every single day activities when we're engaging with victims who are subject to trauma? So we've taken it out of that, and we've made sure that officers understand what victim-centric trauma-informed practice is, and that's how that's our new norm. That's our new business operating model. We understand what perpetrator tactics and motivations look like, the fact that a perpetrator might buddy up with the police officer to try and limit their identification as a perpetrator. We understand what that looks like. We show videos where this has occurred and get members to go, I get what perpetrator tactics and motivations now look like, and why they say, oh, well, she's crazy. Look at her. Yeah, you might have just stirred that poor victim up just before we arrived to give that impression that that victim is the cause of this. So trying to get them to understand there is much deeper going on here in this relationship, and understanding how personal biases impact our decision making. So looking at who we are and how we were raised, and what does a perfect victim look like? Well, you know what? There is no perfect victim. The fact that that victim might be angry or upset or crying or not want to engage with you, there may be some real and valid reasons why that is the case, and understanding that a victim not behaving in a way that they think they should does not mean that they are not the true victim. So getting to understand what our biases look like and how they impact on our decision making. And we're getting ready for the coercive control criminal law when that passes. So there's lots happening in our space.
Do you know, Inspector, I think that as well as saying there is no perfect victim or no stereotype victim, I guess, there's also no sort of formula for how the perpetrator looks either. And sometimes they can look very under control, salt of the earth people, and you just can't imagine them doing the things that it's alleged. But I think this training that you're doing is helping people realise that as well. It's great.
I think that listeners and ourselves, Mum, can take comfort in the fact that someone like you is driving that, and we can hear your connection and empathy to victim survivors. We really actually can feel your genuine concern, and the changes that are happening can give everyone a bit of hope.
Yeah, I'm hopeful. I'm hopeful.
Yeah.
I mean, I think someone who's escaping domestic violence today is going to be better off than someone who did it 3 or 4 years ago. Yeah. And that's wonderful.
And we want to thank you for your time.
Yes.
And hopefully we can have you again another time, Inspector, to talk us through a bit more about the court process and what to expect there. But we can't thank you enough for your time today. And I'm not so nervous about talking to you anymore.
Perfect. Thank you so much, ladies. It's been a real privilege to appear on your show, and I'd love to come back if you'll have me. But I cannot sit and just accept that domestic and family violence is part of our way of life, because it is not. It should never be. And whilst I'm breathing, I'll do everything in my power to make sure that we deliver the best service to victim survivors we possibly can. Will we get it right on every occasion? No, we won't. But I am absolutely dedicated to making it better than the day before.
Thank you so much.
Thank you.
You have a wonderful day, Inspector. Thank you.
Thank you, ladies.
If
Bye-bye.
you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.